Okay, perfect. Well, welcome everybody. While the name under my face says Yvonne Myers, I am in fact not Yvonne Myers. My name is Britt Simmons, and I am the new communications manager for the Fort Collins Area Chamber of Commerce. So I'm going to be helping out today, just kind of teeing up our friend Rachel. So thanks for joining us for Tuesday Talent. We are recording the session, so we'll send it to everyone who registered after the fact. And a quick intro on Rachel, and then we'll get running. So Rachel Ardanuy that's right, Ardanuy.
Correct.
Thank you. Rachel Ardanuy is a business attorney and founder of RZA Legal, based here in Fort Collins. She's been advising entrepreneurs and growing companies since 2015. Her work focuses on helping businesses make smart, practical decisions, mostly around contracts, workforce structure, regulatory compliance. She has built an informed perspective on employee versus independent contractor issues and helps businesses stay flexible while avoiding costly misclassification mistakes. In addition to advising clients, she also navigated these decisions as an employer herself. She's licensed in Colorado, in Florida, and New Jersey. She's a frequent speaker on business law topics that affect growing companies. And that is it. How did I do, Rachel?
That's it.
Did I get it
Fantastic.
all?
Thanks, Yvonne. Britt. Thank you.
Yeah. Okay, so anyway, we're glad to have you here with us today. And Rachel, I'll turn it over to you.
Thank you so much. Good morning,
Sure.
everyone. Thank you so much for joining me. Hopefully, this will be an informative 50 something minutes for you. I see we've got some likely suspects in here. I'm really glad to have many of you in here. So I might, if there's any questions I can't field, I see I've got some payroll folks and some HR folks and CPA folks and others. So thank you all for joining today. So yeah, building a flexible workforce without legal risks. We'll talk about contractors, we'll talk about misclassification, and I will talk about a few other things. Like Britt mentioned, I've started my law firm back in 2015, RZA Legal, down in Denver. I moved up here in 2020, and I've been working across northern Colorado since that time. I'm licensed in Colorado, Florida, and New Jersey. Most of my work is in business and real estate and estate planning. So almost every day I get the question LLC versus trust, and that all depends. So schedule a consult if you're curious, and we could talk about your situation. But I've been doing estate planning ever since the beginning of my career in the law, which is about 14 years ago, and real estate as well. And so business sort of fell into doing that once I moved out to Colorado over 10 years ago. Have a, like I said, background in business management and real estate. I went to the Florida State University for those. When I moved out here in 2015 down in Denver, I sort of jumped right into working with highly regulated businesses in the cannabis and marijuana world. So I've been doing that for 14 years and I'm a bit of an expert on policy and regulation in that realm. Like I was mentioning to Britt earlier, because I've worked with those highly regulated businesses, all other businesses tend to be a little easier than that. So there isn't that extra layer of an extra layer of regulation to deal with in a lot of other businesses. I'm a certified jazzercise instructor. Sometimes I say that's my real career and I lawyer for fun. But I teach at the Jazzercise Center here in Fort Collins. And if you don't know where that is, it is tucked into the corner by the Arc Thrift Store on the south of Drake on College. So I love doing that. I teach 3 mornings a week. It's one of my favorite things to do. Small, locally owned business here in Fort Collins. I'm also an adjunct professor at DU Law. I work with the law students through the externship program, and that keeps me young at heart and really happy and excited for the future. I'm getting to work with those law students. On a personal side, I am a wife. I am a mom of 2 elementary age kids over at O'Day Elementary. And after that laundry list of things about me, I am pretty tired, but I'm also really fun. So hopefully we run into each other. I love attending live music around Fort Collins, had a good time at FOCO MX this past weekend and absolutely love going to live music. So maybe I'll see you out in the world one day. So, a disclaimer, you would expect nothing less from an attorney. I'm not your lawyer yet, unless I am, maybe, but that's not the case in this presentation. This is for educational purposes, not legal advice. If you want to have legal advice, you can set up a consultation with me or another qualified legal counsel here in Fort Collins. We have an amazing bar of fantastic attorneys up here in Larimer County. So, who is this for? This is for people who own or operate a business that use freelancers or contractors or 1099 workers. Those are all very similar synonyms. If you're thinking about bringing on a contractor to keep costs flexible, or if you're trying to decide if somebody should be an employee, looking at what that classification looks like. If you've used a contract off the internet and hoped for the best, I think a lot of us have been there before. If you're growing your team, if you work in HR, if you're working with that, just sort of maybe brush up on what you already know. Um, and this last piece, I think, is, do you have that gut feeling that one of your contractor relationships might not hold up to scrutiny? So we'll go through that today. By the way, if you do have any questions that come up during this presentation, feel free to drop them in the chat, or we can take questions at the end. Hopefully, there will be some time. So this is going to be what we cover today, why it matters, what the legal framework is, the different tests that we are available out there, some classification pitfalls, some recent trends, including some pretty new legislation that passed last year. And like I said, some Q&A. Feel free to chat or put those in the chat. Also, because sometimes it's hard to stay engaged, I have a game for you, which is called Name That Bird. And if you're feeling really engaged, when you see a bird on a slide, go ahead and just type into the chat what bird you think that is, okay? These are all Colorado birds, by the way. My good girlfriend, Jenny Germano, I included her Instagram on here. She is an amazing photographer and has taken almost all of the pictures here. I did have to pull one from the Audubon Society. Oh, and there's one from Canva AI. So let's see which one you can guess is the AI bird image. All right. So why does this matter right now? The gig economy is booming. We know this. A lot of folks, especially, very good, bald eagle. This one, I'm not sure where she saw, but I will, sorry for the segue. I live near like Midtown, and at LeMay and Swallow, there was a huge bald eagle swooping around that intersection last week. It was out of control. So cool. We get to live in a beautiful place. All right, back to the subject. Um, there is increasing use of contractors for flexibility. People want to do work from home. People want to do work across the country. People want to work from Portugal. People want to work from all over the place. And so businesses and workers are trying to figure out what the best way that works for them is. And so that said, misset classification is a huge and common compliance issue. And especially after the past legislation that passed in 2025, there are some really strict enforcement standards here, some of the strictest in the country. So the bottom line is it's not what you want to call someone, it's what the law says they are. And that's what we're here to talk about today. So why classification matters. I made a handy dandy table here for you on some of the major issues that we deal with, employers versus independent contractors. So as you can see, there are significant issues that are impacted, right? Yes, Dawn, it's a mallard duck. Isn't that a cute duck? Um, one of the biggest issues that the government cares about is payroll taxes. If they're not paying, if they're not being classified correctly, then we're missing out on employer paid with payroll taxes. So that makes things tricky. Minimum wage and overtime, that's not necessarily required of a contractor, but it absolutely is of employees. Other benefits like workers' comp, right? You're getting out of the requirement of workers' comp if you're only classifying people as independent contractors, whether or not they fall under that definition. And family, I put required here with an asterisk because the family benefits do depend on, and like contributions of an employer and employee depend on the size of the business. But that said, these are just some of the major overarching concerns. The core question does boil down to who controls the work. And of course, this will be a factual determination every time. Moving some things around on my screen. So who controls the work? This is the fundamental question every time. Do you, as the business owner, control how the work gets done? Do you have SOPs that they follow and steps that have to be done in a certain way that you require? Or just that the thing does get done? And of course, there's some some details that will dig down into that. But as far as, does the company control the means and the methods? Then they're probably an employee. If the company only says, this is the thing that has to get done, I don't care when you get it done or how you get it done, then it's more defensible that this is a contractor relationship. But again, it doesn't really matter if you write a contract that says, or have a signature block that says contractor or something separate from the business. It really will be a fact analysis that the government's going to take. And yes, that was a red-shouldered blackbird. That's a male red-shouldered blackbird. Nice one. I think that one was taken over at the Arapaho Bends. Yeah, wild turkey. Have you seen these turkey gangs around? Um, one of the tests. This is for tax purposes, but the IRS uses. And they look at these three categories of factors: behavioral control, financial control, and the type of relationship. So, and not interesting choice of font color there, but no single factor is determinative. They look at all of the totality of the circumstances to determine if so it's not like you have to meet all three of these necessarily, and there's going to be, some answer on the spectrum of where the behavior falls, right? Does the company control how they do their job? Do you have to sit at my desk? Do you have to come into my office? Do you have to log in and use these specific templates? That's going to be an employee. Financial control. Does the worker have significant investment in their own business? Now, significant is definitely a subjective term, but do they appear to be doing other work? Are you their only client? Are they only working on your clients? Um, is there a profit and loss that they can show that they've invested in their business and then maybe they've lost money or something like that, right? They're not just reliant on your position only, and that's not their only job. And then type of relationship. This really, again, is very detail specific, but is it ongoing? Is it project specific? How integrated into the business are they? Um, and does it appear that they are sufficiently distinct from your business activities? Turkey. All right. Here is another federal test, not used for tax purposes. So actually, let me go back one slide. Whoops, that did not go back. It went forward. So tax purposes, again, this is what I talked about at the beginning when we talk about payroll tax obligation, and does it make sense? And should you have been assessed employee taxes? Should the employer have been assessed employer responsible taxes? And if so, then that's where they're going to glob on penalties and interest and stuff for things that should have been paid going backwards from the time that they should have been classified as an employee. This is the test for Department of Labor for like wage and hour purposes of, so this is tricky. Right now, and this is as of March of 2024, there had been a rule in place, and this is the current official Department of Labor rule. It is a multi-factor economic reality test. So again, just having a contractor agreement is not definitive evidence of an independent contractor. It is necessary. Very good. This is an owl. Um, but there's again a totality of the circumstances, and they are going to evaluate all six of these factors. So again, opportunity for profit and loss. Um, and again, is this something that like you as a business owner could get into and potentially lose out on if you were to enter into that business endeavor, right? Um, Investments by the worker and the potential employer into the project. The degree of permanence of the work relationship. Again, is this someone that's going to be sort of on your team long term? But and again, if that's the case, that's okay. if some of the other factors are not there. So again, like one of these factors, it's going to be hard to say because when you hire a contractor, typically you're going to want your values aligned and they're going to scratch a, check a box that you expect them to check that needs to be checked in your business that could possibly be checked by an employee. But that's where you want to sort of balance out the rest of these factors. And so, how permanent is the work relationship? Is again, is there an end date? Is this project based? Um, what is the nature and degree of the control that the business has over the way the worker is getting the work done? Can the worker say no? Can the company say, "Hey, do you have the bandwidth to do this?" and the worker say no? That's an important factor of being a contractor. If they have to do whatever it is that you're asking in that professional description, that's going to be leaning toward an employee relationship. Um, whether the work is integral to the employer's business. We'll talk about that in the next test, which is the Colorado test. And then what's the skill and initiative of the worker? So again, while yes, you must have a contract at a minimum to establish contractor relationship, that's not determinative evidence, and they're gonna the government and or the courts are going to apply this test. Now, I have a note here. Hopefully, we'll get these slides out to you quick enough because this blue language at the bottom is a hyperlink. I'm not sure you all can access that right now. I'll try to drop that in the chat or get that out to you. But there is a new rule that's been proposed by the current administration under the Department of Labor that would change the rule to a two-prong approach. And it's two of these prongs. I forget which one, but importantly, they are still accepting public comment through almost midnight tonight. This is the very last day for public comment on the proposed new rule, federal rule, for determination of wage and hour purposes. And so, if you look back over time, if you click on this link, if you look at the Department of Labor's information online, you'll see that they've gone back and forth on how they evaluate whether someone is an employee or a contractor. As you can see, when you go there, again, it's going to a two-pronged approach. That's the proposed rule, as opposed to this multi-factor economic reality test. They're really not that different, but they do, let me know what you think. So go ahead and please, if you care about this area of law, if this is something that you and your business do evaluate, if it is something that you're considering in building and growing your team in a flexible way, it might be important for you to look at, would it be preferable to determine what that relationship looks like under these factors or under the proposed rule, which is more of a two-prong approach. So here's the Colorado test. And again, that blue language is the ABC test. That is a link. And I can get that hopefully out to you all. Whoops. So again, we talked about how Colorado is much more strict. So this test, I referenced the Colorado revised statute there. That references Colorado's wage laws. Yes, those are Robins. Very good. This is used for determination of unemployment insurance, workers' comp, and also wages. So this is the general rule in Colorado. This would also be the rule if some worker wanted to sue their employer or the place of work to determine if they were misclassified and seek damages that way. So importantly, and this, if you take nothing else away from today, I want you to take away that in Colorado, workers and all work is presumed to be employment unless the employer can prove otherwise. And so the fallback standard relationship of worker and hirer is employment, which means taxes, family, payroll tax, employer paid FICA, those kinds of things. Enrollment in workers' comp, and all of the other protections for which the Department of Labor and labor laws have been created. So the ABC test, I've got it laid out here. We'll dig a little deeper in the next few slides. But these three main prongs, and again, all of them must be proven in order to show that this is a contractor and not an employee. Control, so completely free from control and direction in performing the services, not only just in the language of the contract, but also in actual practice. So, again, no sort of quality control, overseeing, no supervision. Those things can be, as far as quality control or outcomes, those can be as defined as you would like them to be in the independent contractor agreement, and I highly recommend that. Actually last month, I spoke at Founded in FOCO and did a presentation on service agreements. And I provided a draft service agreement, which is an independent contractor agreement. That could be found in one of my blogs on my website, RZA Legal, under the blog that said, I think it says resources for Founded in FOCO. But one of the things on that template that I provided was an exhibit of like, what is the statement of work? What are the deadline expectations? And that there's no reason why that can't be as detailed as possible, but it can't say, we are in our sole discretion going to determine whether or not this meets our standards. Those standards need to be laid out, and it doesn't need to necessarily direct, or it cannot direct exactly how that service gets performed other than, in good workmanlike manner, et cetera, et cetera. And again, you can build in some standards, but not direction of how it gets performed. Hopefully, I'm sharing that distinction clearly here. For B, prong B is outside the usual business. So the service, and this is sort of another really sort of precise distinction. The service is performed outside the usual course of the employer's business or outside all of the employer's places of business. So we'll get into that on the next one of the next few slides here. And prong C, independent business. Is that worker customarily engaged in an independent established trade, occupation, profession, or business? And so again, the burden of proof is on the employer, not on the worker, when it comes to if the government is curious that you are or not paying proper employment taxes or properly enrolling or covering people with workers' comp. So what do the prongs mean? Let's dig in a little bit. Prong A, control. Are they required to work specific hours? Yes. I think this is a Cooper Hawk, actually. I'll have to double check that one. Um, Required to work specific hours. That's problematic. Now, it really depends on what the work is. Is this a plumber who's coming in to fix something in, the facilities that are during business hours? Can you say, oh, you'll come before business hours or after business hours? Yes, that's okay to do. As far as detailing those hours under which your contractor can work as it relates to the operation of your business. But if you're saying uh, you need to show up here from 9 to 5, that is very problematic for a contractor. They must attend your meetings or check-ins with you, even though that's less than, yes, you have to report to the office 9 to 5. It still could be problematic. And I think building in, if this is a contractor where they work on project basis, but they do a number of different projects for you, is it important for you to sort of communicate on that? Sure. And you can certainly detail communication in your independent contractor agreement and in practice, but sort of requiring them to join the team meeting every week could be a concern. Do they use your tools and equipment? Now, I've seen this sort of go both ways. If you go to the independent contractor guidance on the Colorado's Department of Labor website, they sort of make distinctions of tools and equipment. But the point being is that if they just have to show up and do your work for your company on your equipment and tools, that's concerning. And that makes it look more like they are an employee and leads the prong A toward employee status. And then are they supervised? Are there performance reviews? problematic, right? Because if this was truly a contractor, or if they were not meeting the terminate the contract, period. If this is someone that you're, invested in, you want them to stay long term, they deserve employment benefits and protections, and they are an employee. So, I considering those things when some I've received questions about seasonality. What if it's just a seasonal employee or something like that? That again really does dig into what level of control do you have? Can you say, yes, we're going to hire you on a contract basis. Um, you have to harvest certain amount of product if it's like an agricultural business that's seasonal or a hospitality business that's seasonal, kind of laying out what those look like. Does it that even seasonal businesses, your seasonal clientele, or rather employees, can still be employees and not just contractors? Steph had a question. As a mental health facility, we have some requirements as mandatory report training. Is that something contractors can be required to complete? Yes, that is. That's a really good question. And so, if it is a precursor to them being able to even serve in that capacity, in order to operate at your facility, then yeah, I mean, that's something that you can require of them ahead of time. It's something that, um, as far as asking them to complete it on the dime, I think that's something that should be negotiated. If is this specific training that they could receive elsewhere, or is it portable training that would mean something elsewhere? But that's something, those are factors to think about too. But if it's your specific training, I do think that that could be something that could be a precursor or a requirement, a condition precedent under legal terms, to be a contractor at your facility, as long as they're being, there's a value to that, and they're being compensated for their time for that. What? So the next prong, that was prong A. Um, and again, I sort just to further address that question, um, that could go toward the qualifications of the contractor, right? I mean, if you were doing an RFP for contractors to fulfill a role at your facility, that's certainly something that could be included in, a minimum qualification, or again, a condition precedent of getting started on the project, that they have that training completed in order for you to maintain compliance with whatever regulatory body it requires of your facility. Yes, the Blue Jay. This was the only one I had to get from the Audubon Society, which is kind of crazy because we have Blue Jays everywhere, in Fort Collins and across Colorado. But I guess I couldn't find one that Jenny had taken of the Blue Jay, so that's why we get Audubon here. Um, Prong B is it outside of your usual business? So I have some sort of examples here, which again, this is tricky. This one is very tricky. I think this one is the hardest prong to satisfy. Are you hiring a graphic designer to work for your law firm to create content, or design out your office? That's defensible if you're hiring them on a contract basis. Totally different area of practice, not practicing law. Hiring someone to do legal research for a law firm, that could be a little bit risky. Again, I think that's when we would look to the other prongs too, because legal research is an activity that takes place in a law firm. But if it is a distinct service that's being provided that is additional to what the employment or the employees are already taking on, if it's a distinct project, right? If it's for, support for one trial or something like that, then that's a little, less, it's more defensible again, as far as the contractor status. And then performing work related work outside of the place of business, because remember we talked about that prong B being, is it outside the usual business practices and industry, versus outside, working outside, completely outside of their places of business. So also slightly less risky if they're doing related work, but it's supplemental to what your business does, and they're not working at your facility. You're not, again, not providing those additional equipment and tools, things like that, not requiring them to log in on your workstations. So prong C, the last prong of the Colorado test, is that the analysis of whether the worker has an independent business or is doing work elsewhere. So these are sort of questions you want to ask yourself is, do they have their own clients? Um, do they have their own business license or entity? Are they set up as an LLC? They should be. I think that is a pretty big distinction in Colorado, sort of belt and suspenders of confirming this. Yes, they're independent, they're operating as a business entity in the state. Do they carry their own insurance, malpractice insurance, general liability insurance, benefits? Yes, these are egrets. It's a party of egrets here. That's down near Chatfield, that picture. Can they work for your competitors simultaneously? Now, doesn't have to necessarily be your competitors, but can they also operate? Is there, any concerns like that? Can they also operate in the field? So these are all sort of questions you want to look at to determine does this person meet prong C? And while the employer or the company, I should say, has to prove A, B, and C in order to meet the status of a contract relationship in Colorado. That doesn't mean we have to answer all of the questions under each of these prongs as a yes. Again, I think it's a balancing test of whether or not there's enough evidence to show A, B, and C exist. So here are some red flags that I have seen in my decade plus 14 years of working in the law with businesses. These are real situations, and these tend not to be um, purposefully decided this way. I don't run into folks who are typically trying to avoid employment taxes, or at least not explicitly. Usually it's these things that we come across. So is it a contractor that just works for you full time indefinitely, even if that's not the way it started? Um, you call them a 1099 or you call them a contractor or you call them a consultant, but they show up on a set schedule. They come to the office you rent for them. They use your tools. They're part of your core business work. Um, Calling them that because that's the title that they've requested doesn't matter. Um, Using the same contractor agreement for every worker without individual analysis. So when I said I made that draft contract, that master services agreement for the FOCO, founded in FOCO, um, that presentation was geared toward the worker, the actual contractor who is trying to engage with other businesses to provide services. And so, while that might be useful to a company here or who views this presentation in the future, just something to think about is that like this, you want these agreements to be tailored based on the contractor and the contracting company, ideally, that's going to come out here. That's going to come here. So that would be a concern in an audit, a Department of Labor audit, if you had identical independent contractor agreements for everyone without any sort of individual analysis of what they're doing, laying out again what the scope of work is, what the deadlines look like, and those other specific terms. A long-term freelancer who's become integrated into daily operations. This happens a lot, right? And this is where the other factors come into play. I'll give you an example. I have a bookkeeping company that I've worked with for 8 years with my law firm. I love my bookkeepers. Um, I email with them constantly. They are definitely integrated into my operations as far as sending out invoices and collecting on invoices and managing my books and balancing my trust account and things like that. But even though they're integrated in the daily operations in that way, we have a contract. They are a company. There is a set payment that I make for them. I don't tell them when and where and how they do their bookkeeping. They have that full independence. And so I feel very strongly that the payroll company, I'm sorry, not payroll, the bookkeeping company that I've hired, even though I've worked very closely with Bill for over 8 years. He works for that company. They are a vendor, a contractor. And even though the work that they do is long term and that they're integrated in daily operations, he would not fall under freelancer. He's an employee of the bookkeeping firm, and that sort of keeps that misclassification from taking place. They invoice me every month. They have their own separate tax identification number. So all of those sort of factors go to, again, like I don't control the way they do it. They don't work at my facility. Um, they don't work in the same type of business that I do. And while they're integrated into my operations, they have their own distinct business practices. Um, the contractor whose role has quietly expanded well beyond the original agreement. I'm not saying these are bad things, right? These are great. This means you've found the right people for your team that support your team, which is important. Um, but that just means we need to change the classification of the relationship or put boundaries around what it looks like so that way they do remain in compliance as independent contractors in practice and on paper. So I mentioned earlier, let me back up here. Here we go. So here are the penalties for Colorado. House Bill 25-1001 went into effect. There was a blog recently by the folks from Journey Payroll at Fort Collins Chamber email. You may have read that. I think that was a couple months ago, but talked a little bit about this bill that passed last year. And it didn't change the test. It didn't change the ABC test. It didn't change the obligations that we have for documentation. It just changed the enforcement and the fines available. And so previously, it was focused on primarily on wage recovery. And again, like I said, when you misclassify employees as contractors, the government sees that as payroll fraud. They're missing out on certain taxes. People aren't getting the benefit of employment protections that the laws provide. And so that was the main concern prior to this legislation. There wasn't really standalone civil penalties that applied to violations here. It was really just what should have been paid and some, interest and penalties related to that. Now, this is treated as a distinct enforcement issue. So there are standalone, so the Department of Labor can do investigations, can determine whether or not someone is an employee. And a lot of times this stuff doesn't come up until there's a wage dispute, right? Or a payment dispute. So if someone is previously classified as an independent contractor and like that last slide mentioned, maybe some of their duties has drifted, maybe they look a little bit more like an employee based on the work that they're doing. If something goes sideways with that relationship, then that's where the initial first step that we're going to see is a complaint with the Department of Labor, and then they will do an investigation to determine, is this a distinct issue? If it is, do we have this schedule of fines? So if they find that it is a willful violation that you have meant to put them as a contractor when in fact they were an employee. That's up to $5,000 fine per employee per worker, and then it just graduates up from there. If you don't fix it and correct it within 60 days of getting a notice from the Department of Labor, if there's a second willful violation, if you're a repeat offender, it can really stack up, and that's just with the state of Colorado. So, again, on that list of red flags, were any of those willful violations? Likely not, right? Again, a lot of times these relationships start harmlessly, and maybe they are actually just project based. And as those people prove to be competent and good parts of our team, we wind up giving them more work. And then again, it sort of drifts into this employee side of things. that's, where we get into trouble here. And if it doesn't get remedied, that's where we're going to be seeing, unfortunately, some fines from the Department of Labor. Now it all stacks up too. It still puts you out to federal um exposure. So, I have the bill and again the statute here for Colorado law, but back wages, overtime, if for some reason the work put in by that worker doesn't amount to minimum wage, unemployment premiums that should have been paid to cover such person. So it definitely can stack up. So those are the Colorado penalties. Federal penalties, there's a multiplier effect. So, if there's unpaid employer FICA taxes, failure to withhold penalties and interest going back from the beginning, any unpaid overtime, minimum wage violations, double liquidated damages, and then also employees' attorneys' fees. So, something to think about there. And a lot of these statutes provide for attorney's fees. So that can really get, again, that multiplier effect. So if you have a misclassification finding at the state level, they're going to share that information, right? See, the Colorado Department of Labor and Employment, they share their findings with the Attorney General's Worker and Employment Protection Unit. So then they could go, the Worker and Protection Unit could go after you for various other issues. So fines, back wages, penalties, these can all really add up to threaten a company when really they were just trying to um, grow their business in a way they thought would save them some money. So things to think about there. I'm sorry about the formatting on this page. I'll try to get that fixed before we get that posted, but I still think you could see everything here. So um, on the totally right column, I've got different factors here. And then, you know, these different columns here for whether they're a contractor or an employee. So for instance, control over the work. If you control how the work has to take place, that points to the relationship being an employee. If they control how it works, the worker, then that would point toward a contractor. So when most of the factors here, you can use this as a quick reference sheet to consider each of your team members and decide, you know, does this look more like an employee or more like a contractor? And if they are currently um, engaged with our business as a contractor, then that's something that we would want to transition over. And I will say it's a red flag to transition in the other direction. So, what does a good independent contractor agreement cover? Again, go ahead and take a look at the service agreement if you're interested in looking at that. But it does matter that you have a contract in place. Um, yeah, we'll definitely share out these slides. I think they'll be posted on the chamber website as well. And if you don't mind, if you want me to just email them to you as well, just put your email in the chat and I'll make sure that happens. Um, so here I have a list here of some key provisions in an independent contractor agreement. These are kind of really important ones that should be in there. Clear scope of work. Is it project based? Is it results based? What exactly is expected? That you're only controlling the results and not the methods or the schedule. So again, you can say the due date, but not the methods in which they get it done, not the hours in which they do it. So, if I'm working with a contractor, and I've done it too over time, like I mentioned, like Britt mentioned at the beginning, I've had my law firm for 14 years. I'm sorry, I've been I've been an attorney for 14 years. I've had my law firm for 11 years. And in those 11 years, I have had various relationships with vendors. I've had contracts. I've had independent contractors help out for distinct projects. I've had part-time employees. I've had law clerks. I've had interns who are employees if you're paying them. So, I've gone through the whole gamut of relationships to serve my firm. And these are all things that I've had to determine as well. Um, if the contractor provides their own tools and equipment, I think we might have some tradespeople on here. If you are subcontracting, that is a version of an independent contractor agreement, and that will should have these key provisions in them as well. And if you are using their tools, then that is something that is going to, again, it's going to lean toward employment. And I know that is a little bit scary, but it really isn't that much more to deal with once you have systems in place, like an HR. If you work with a payroll company, a lot of times they handle a lot of that stuff. If you're more hands-on, my bookkeeper handles we process through a payroll company, and my bookkeeper kind of does that sort of quarterbacking in the middle. So, there are systems in place that can make employment and employing not so painful or expensive. And those working with an HR, company or payroll company is definitely worth their weight in gold because you're probably not in the business of doing that work, right? You're in the business of providing the service that your business is passionate about, practicing law, interior design, providing services for care services for folks with dementia, right? All kinds of other things that they may work for other clients. So there has to be non-exclusivity in that contract. That doesn't mean that they don't have to maintain confidentiality. That is distinct. And you can absolutely require confidentiality of an independent contractor. No benefits, no workers' comp, no unemployment, I'm sorry, no unemployment insurance provided. The law does require that has to be in bold or different typeface, so it's obvious and different than the rest of the language of the contract. Also, I would recommend in bold that the contractor is responsible for their own taxes, and ideally with an indemnification that if in the event the government or the taxing agencies try to come after the business, that the contractor will indemnify the business because the contractor agrees that they are a contractor and responsible for their own taxes. The right to subcontract if applicable again, and then also not suggesting that they're integrating into daily operations as a part of your firm or part of your team. So again, it's not just the contract. The contract is important and necessary to have to try to even start the independent contractor discussion. But it should reflect a relationship that can actually pass that ABC test and not just pay lip service to it, but not actually reflect reality. And this happens a lot, right? If you pull up an operating agreement off of the internet, because you want to get, your business started up really quick, and you don't tailor that to what's actually happening in your business, then you're not going to be happy with it when, stuff goes sideways and you need some sort of guidance to, resolve any issues with your partners. A note on AI. Can you identify this Colorado bird? Generative AI platforms are not bad for a first rough draft, um, or to review an agreement that you may not have considered. But all AI platforms lack substantial legal skills and accuracy. They are only as good as what gets put into them, and a lot of garbage gets put into them. And so I say AI is a very bad lawyer. It's like a very overzealous first year intern who's never practiced before but knows the terms. So, and I'm not trying to, poo-poo any externs. They're fantastic. I love working with externs and interns. But there is a reason law school is 3 years long. Remaining on top of things is really important, and the law constantly is changing. And so those AI contracts are not always fair. They are not always legal. They usually have provisions in them that are not enforceable. And they're definitely not protected by attorney-client privilege. We've been seeing a lot of courts come out lately where folks are taking work product that they get from their lawyer, a draft contract, putting it into AI to have it sort of be a second opinion, And then they've lost that attorney-client privilege as soon as they've uploaded that document into AI. And so if it's important to you to maintain privilege, maybe the terms of an agreement you have with someone are with the world and they're subject to confidentiality. You're going to break that confidentiality seal once it gets uploaded into AI. So something to consider there. It's a great tool. It can give you ideas on things to consider that maybe you haven't considered, but definitely consider them a rough draft. So here are some, quick sort of ways to build your flexible workforce the right way. Here are some ideas for some legitimate flexible workforce structures. True independent contractors. Not, I'm not trying to poke holes in every relationship, but again, work in Colorado is deemed employment unless the ABC prongs are all met and dollars. Classify them properly, do the appropriate withholding, pay your payroll taxes, pay your local occupancy taxes if that's required, or I'm sorry, occupational taxes. Um, and make sure that those all get taken care of in the right way. How, again, depends on a few different factors as far as whether or not the company contributes to family or if the employee contributes, how much, that kind of thing. Um, Staffing agencies, usually they're, and this kind of blends in with PEOs as well, but different arrangements so that there are either whether it's a joint employer or a third party employer who's handling all of that stuff, and then you're sort of the client of that third party staffing agency or PEO. And fixed term employment agreements. So, you can certainly have an employment agreement that has an end date on it based on a project. And then you are not necessarily on the hook after the fact. It's simply project based. Um, or full-time employees. So there's still many of flexible ways to grow your team in the right way. I run into this too. I go through ebbs and flows in my business, and sometimes I need more help, and sometimes I only need part-time help. And figuring out what the right mix is that is legal and compliant is definitely doable. It's just figuring out what works for both the company and the worker. So again, some key takeaways. We presume employment here. You have to prove contractor status, not the other way around. The ABC test is standard. All three prongs have to be met, in fact and in contract. What you call yourself does not control the actual working relationship controls. Um, we have enhanced fines for violations of misclassification in Colorado, so keep an eye on that. And I would say a way to, sort of deal with all of these things, few more bullet points down, is audit regularly. Relationships evolve, classifications may have to evolve with them. And so putting it on your calendar, I'm not saying do performance reviews for all of your contractors because that would lend that they are employees, but evaluating the relationship regularly, quarterly, putting it on the calendar is pretty important. And just having those conversations, right? And then get help before there's a problem. I wrote here not after, but it non-negotiably get help after if there is a problem. But what my point is by that last key takeaway is let's try to get some guidance ahead of time before there's a problem. One thing I'll say as an aside is the Department of Labor in Colorado does provide advisory opinions on whether or not someone falls a contractor or an employee. They're $100, and you can find information on that through Department of Labor, Colorado Department of Labor and Employment's website. So, that could help guide you if you don't want to go the route of working with an attorney where you have privilege and client attorney confidentiality. But that's one possible tool out there as well, especially if you work with a larger firm and you're seeing a lot of folks that are similarly situated related to your firm. And does that make sense that they're a contractor or an employee? You can seek an advisory opinion from the state on that. That being said, they will be binding and they will hold you to that. So thanks all. I don't know if you recognize this little guy. Um, This QR code here in the middle, if you want to sign up, I do put out a monthly newsletter. I put one out this morning actually for April. But you would also get a free copy of a guide that talks about different contracts in business and at the various stages. You don't need all the contracts all at once. So if you're interested in my monthly newsletter, feel free to reach out on that QR code. And if you ever have any questions, like I said, I'm a chamber member. You can find me on the member directory. You can go to my website, rzalegal.com. My office is in Midtown, and love working with clients on just, sometimes it's just doing a 90-minute business and legal strategy session and not necessarily hiring us for a discrete project, but sort of just figuring out what you don't know, or maybe some strategy on how to grow or exit your firm or provide business succession planning and into estate planning. So always happy to chat about those things. And I appreciate the chamber for having me on today to talk about workers and growing the team. Talent Tuesday.
Perfect. Thank you, Rachel. I appreciate it. And thank you everyone for attending. Again, we've recorded this presentation and we will send it out to everyone who joined. So with that, we will see you for the next one. Thanks so much, everybody.
Thanks for playing Name That Bird. Hey, Trevor.
All right. Bye bye, everyone.